Secretary of State for Foreign and Commonwealth Affairs, and Libya and Janah.
Abstain.
My Lord, my Lady. Begin with representation, if I may. Mrs. Jessica Wells and I appear on behalf of the Secretary of State for the Foreign and Commonwealth Office. Mr. Timothy Ottey QC and Mr. Paul Luckhurst appear for Ms. Janah. Mr. Aidan O'Neill QC appears for the Air Centre, which is the first intervener. Mr. Arfan Khan and Mr. Tahir Ashraf represent 4A Law, the second intervener, and they've made, they're here by way of written submissions only. In the Janah case, Libya does not appear and is not represented. The court may recall that Libya appeared before the Court of Appeal and was granted permission to appeal to this court, yes. But this court required a payment into court, which has not been made, and so Libya has no right to appear. In the Benkharbouche case, neither Ms. Benkharbouche nor Sudan are here or represented. Before the Court of Appeal, the Secretary of State exercised his right under Section 5.2 of the Human Rights Act to intervene and to be joined as a party. And so consequently, in the absence of Libya and Sudan, the Secretary of State is now in the position of the sole appellant, although the Secretary of State is not, of course, a party to the underlying claims that are in issue. I shall focus on Ms. Janah's case, as it covers all of the issues and she is represented. But the Secretary of State does appeal in both cases. The only significant point of difference to note is that no finding of fact has been made as to Ms. Benkharbouche's state of habitual residence when she entered into her contract of employment with Sudan. So there would be a factual question as to whether or not Section 4.2b of the State Immunity Act applies to her. Turning then just to make some introductory remarks and give you an idea of my roadmap before addressing the matters in substance. In accordance with the clear and express terms of the State Immunity Act 1978, Libya has immunity from the jurisdiction of the UK courts. The Court of Appeal has disapplied that immunity in part, and to the extent that it has not been disapplied, declared it incompatible with Article 6 and Article 14 of the ECHR, and my submission is that the Court of Appeal erred in doing so. In short, given that historically, as a matter of customary international law, state immunity was absolute, it logically follows that any erosion of state immunity must be established as customary international law in accordance with the ordinary rules for identifying customary international law. As the Court of Appeal recognised, nowhere is the difficulty of establishing whether and to what extent immunities have been eroded more apparent than in the field of embassy employment disputes, where state practice is diverse. That's paragraph 21 at MS 430. That being so, the grant of immunity on the facts of these cases falls well within the UK legislature's margin of appreciation. Margin of appreciation is, of course, a concept applied by the European Court of Human Rights as an international court. Nevertheless, in my submission, Parliament is entitled in this context, where there can be no doubt as to the effects of the legislation, to the same margin of appreciation, even if one applies a different label. If the court doesn't mind, I will stick with the label margin of appreciation on that understanding.
Of course.
The right of access to a court is a right to an adjudication, just as the right to an adjudication is inherent in Article 6 and Article 47 of the Charter, so too state immunity is an inherent limitation on the scope of that right. As a court has no power to adjudicate in circumstances where a state has immunity from the court's jurisdiction, the grant of state immunity falls outside the scope of the implied right to an adjudication, and neither Article 6 nor Article 47 are engaged. I would note at the outset that while we focus on Article 6 of the European Convention on Human Rights, it has been common ground that insofar as relevant to the present case, the content of Article 47 is identical to that which we find in Article 6 and Article 13 of the ECHR. The scope of those provisions, what they cover, is different, but the content is the same. So we say that if Article 6 is not engaged, then nor is Article 47 of the Charter. In any event, if the grant of immunity is not idiosyncratic, then it will fall within the state's margin of appreciation, and so, as a matter of principle, it is proportionate. Equally, we say a grant of state immunity which differentiates on grounds of nationality.
What do you mean by idiosyncratic in that particular context?
I mean, well, we will see the way that the European Court of Human Rights approaches it. My submission would be that if the UK adopts rules of state immunity which fall outside of what is a tenable view of public international law on this subject, then they're taking an idiosyncratic view. One can't simply take the label state immunity and apply it to anything and then say that Article 6 is not engaged. But if the view taken and expressed within the State Immunity Act is a tenable one, it's not outside the range of views represented by states, then in my submission it wouldn't be an idiosyncratic one. In any event, in relation to the Article 14 or the discrimination point, we say it is justifiable to treat those who can properly be characterised as part of the forum state's labour force by reason of being a habitual resident or national of the forum state differently in this context to those who were not recruited from the local labour force. As regards embassy service staff, those recruited from the local labour force are not in a comparable position to foreign nationals recruited from abroad. The latter, people such as Ms. Janah, themselves benefit from privileges and immunities, whereas the local labour force do not. So turning to the case then in more detail, I propose to begin with a brief outline of the facts and the procedural history, take you to the key statutory provisions, and then I'll address the following questions. So firstly, is the grant of state immunity within the legislature's margin of appreciation in taking a view as to the effect of customary international law? Secondly, is the right of access engaged by the grant of state immunity? Thirdly, if it is engaged, is the right of access breached by the grant of state immunity? And fourthly, is the grant of state immunity unjustifiably discriminatory on grounds of nationality? Now, we accept that an untenable view of state immunity would engage Article 6. So it's for that reason that what we are looking at the beginning at the question whether or not the legislature is within its margin of appreciation in granting immunity in this context. And so we will also be looking within that first, within the answer to the first question, at the European Court of Human Rights case law to see the approach that has been taken to the margin of appreciation. As a result, quite a lot of what I'm going to end up saying about proportionality, the third point, will end up to some extent being covered, or to a large extent being covered within the first point. But firstly then, to go to the facts, if you could turn up in the core volume, MS 490, this is the Employment Tribunal decision, and we see the findings on page 497. So, Ms. Janah, paragraph 12, we see is a Moroccan national. She was living in Libya in 2005 when she entered into a contract of employment with Libya to work for the Libyan embassy in London. And we see from paragraphs 12 and from 15 that she came to the UK in order to take up that employment. She worked at the Libyan ambassador's residence as a member of the service staff of the mission. And we see at paragraph 17 her duties included cooking, cleaning, laundering, shopping, and serving meals, including to the ambassador's guests. As Ms. Janah notes in her statement of claim, which we have at 589, paragraph 11, on the 1st of May 2011, Mr. Gelban, who was then the Libyan ambassador to the UK, was expelled from the UK. He was declared persona non grata by the then Foreign Secretary, William Hague, and given 24 hours to leave. As the court will no doubt recall, at that point in time, Libya was in the midst of a civil war which had begun in February 2011 and which ended with the death of Colonel Gaddafi in October 2011. And as the Employment Tribunal noted at page 497, the next ambassador, this is paragraph 16,
Yes.
Mr. Nakwa was appointed following the change of government in Libya. That was at the end of September 2011. Ms. Janah was dismissed by the new government of Libya in January 2012, and in April, 19th of April 2012, she issued a claim in the Employment Tribunal. And at 591, this is within the claimant's, Ms. Janah's statement of claim, we can see the claims, the nature of the claims that she made. So there's reference in paragraph 18 to the initial, the dismissal on 21st of January, which was followed up, paragraph 19, by the letter from the National Transitional Council. And then paragraph 20, we see the various employment claims brought pursuant to UK statutes. Then turning to page 488 of the core volume, we see that Libya successfully claimed immunity.
Sorry, what hearing? What page is this?
488.
Oh yes, I've got it. Sorry.
So this is the judgment follows immediately after, but this is the order from the Employment Tribunal. And we see from paragraph 1 that Libya successfully claimed state immunity before the Employment Tribunal. Her appeal was then joined with Ms. Benkharbouche's appeal before the Employment Appeal Tribunal. And we have a summary of Mr. Justice Langstaff's judgment. His judgment starts at page 462. It is summarised within the statements of facts and issues at page 192. And at paragraph 18, we see there that in light of the jurisprudence of the European Court of Human Rights, in particular the judgments of the Grand Chamber in Kudak and Sabe, he found a breach of Article 6 in respect of Section 16(1)(a). He was prepared to assume that there was a breach of Article 6 read with Article 14 insofar as Section 4(2)(b) of the SIA was concerned. It was not possible to read down either provision, and as the EAT had no jurisdiction to grant a declaration of incompatibility, and he held that these provisions were inconsistent with Article 47 of the EU Charter. He granted permission to appeal, and the order of the Court of Appeal is at page 402. And we see at page 403 the declarations that the Court of Appeal has granted and against which the Secretary of State appeals. So in the context of the claims brought by the appellants, now the respondents, Section 16(1)(a) and 4(2)(b) of the State Immunity Act 1978 are to be disapplied to the extent necessary to enable the appellants to pursue those of the claims set out in their respective ET1s falling within the scope of EU law. And then 3.2 gives a declaration of incompatibility insofar as the claims are not within the scope of EU law. So in broad terms, the question before the court is whether Libya enjoys immunity from the jurisdiction of the courts and tribunals of the United Kingdom in respect of the employment claims Ms. Janah has brought. On a straightforward reading of the State Immunity Act 1978, it's undoubtedly the case that Libya does have such immunity. If one can turn up the State Immunity Act, which is in Core Authorities Volume 1 at tab 3, the first key provision is Section 1, and under
Is this in fact disputed that?
No, it's not.
It was common ground that there was no immunity according to the Act. The sole question is whether that is consistent with Article 6, 14 and or 47 of the Charter.
Yes, that's right. It isn't suggested that these provisions can be read down. And so that's why it is only a question of disapplication or incompatibility. But so that we can see the provisions that are in issue, if I may just take you first, we see Section 1, the general immunity from jurisdiction. A state is immune except in relation to situations where specific exceptions set out in sections 2 to 11 apply. The terminology is immunity from the jurisdiction of the courts. And we see that it has to be given effect irrespective of the foreign state, of whether the foreign state appears. The only exception that could even potentially apply is Section 4. No, this is not a case where, for example, any allegation of personal injury has been made, so it's not a case where Section 5 is in issue. But there are two provisions which demonstrate, as is common ground, that the Section 4 exception does not apply, and those are firstly Section 4(2)(b). At the time when the contract was made, the individual was neither a national of the United Kingdom nor habitually resident there. And Section 16(1)(a), which states that Section 4 above does not apply to proceedings concerning the employment of the members of a mission within the meaning of the convention scheduled to the said Act of 1964. So it doesn't apply to those who are members of the mission within the meaning of the Vienna Convention on diplomatic relations. So, as we'll see in due course, Section 4 is materially identical to Section 5 of the European Convention on State Immunity, which is variously referred to as EXI or the European Convention or the Bâle Convention. I'll stick with the Bâle Convention, if I may.
We also need, don't we, the final words of Section 3, because those are the words which establish, as a matter of English statutory law, that the dichotomy between sovereign acts and non-sovereign acts doesn't apply to contracts of employment.
Well, there would obviously be a question as to whether or not Section 3 would otherwise apply, as to whether or not an employment contract would fall within the terminology of commercial transaction. I understand, of course, that's something the court's considering in another case, but yes, Section 3 makes clear that the Section 3 exception does not apply to contracts of employment. So the scope of the exception to the general rule of immunity in Section 4 of the State Immunity Act is initially explained in relatively broad terms in subparagraph 1, but the ways in which its scope are cut down are then specified in subparagraph 2. And the key point for our purposes is the exception to the general rule of immunity only applies to employees who, when recruited by the foreign state, were habitually resident in and or nationals of the UK. So in effect, and subject to any other limitations on its applicability, immunity is lifted if the foreign state recruits employees from the local labour force to work for it here. Section 16(1)A takes us to the Vienna Convention on Diplomatic Relations because it incorporates by reference the definitions in that convention. We have that in tab 1 of the same volume, Core Authorities 1, starting at MS 791. Now, this convention is, of course, in force, and almost every state is a party, 191 state parties to it. The definitions are in Article 1, and in particular I'd flag up B, C and G. So we see members of the mission include staff of the mission, members of the staff of the mission includes service staff of the mission, and then members of the service staff are the members of the staff of the mission in the domestic service of the mission. Note also, subparagraph I, the premises of the mission includes the residence of the head of the mission. So the ambassador's residence, where Ms. Janah worked, forms part of the premises of the mission. Whilst we have the Vienna Convention open, there are a few points I would just flag to save us coming back to it. If the court would turn firstly to Article 37, we see at Article 37(3), members of the service staff of the mission who are not nationals of or permanently resident in the receiving state shall enjoy immunity in respect of acts performed in the course of their duties, exemption from dues and taxes on the emoluments they receive by reason of their employment, and the exemption contained in Article 33. So Ms. Janah herself, she falls within that, and so she enjoyed immunity from the jurisdiction of the UK courts in respect of acts performed by her in the course of her work, as well as exemption from dues, taxes, national insurance, and so on. And as we see from the preamble, if we go back to page 792, the purpose of the state parties to this convention in granting this immunity to Ms. Janah in respect of the acts performed by her, that purpose is stated, it's not to benefit individuals, but to ensure the efficient performance of the functions of diplomatic missions as representing states. So the immunity from the jurisdiction of the UK courts is not one way. Libya has state immunity in respect of Ms. Janah's employment claims, but equally Ms. Janah has diplomatic immunity in respect of her work for Libya, as well as the privilege of not paying UK tax and so on. I would also note, whilst we're here, that Article 37 draws distinctions based on nationality and residence. Members of the UK labour force who work as service staff for a foreign embassy in the UK don't have immunity, and they have to pay tax in the usual way.
At what stage does one ask the question whether somebody is permanently resident in the receiving state? I mean, one might be employed as part of the domestic staff of an embassy and become permanently resident in the course of doing that, or is that not possible?
Well, in my submission, in circumstances where an individual is in the UK on a diplomatic visa, they wouldn't be somebody who would be regarded as permanently resident. They wouldn't fall within that definition. So I would
Because their visa would expire when their job stops,
Yes.
with, I think, an exception relating to transfers to another member of the same mission.
Yes, so I would certainly accept that this provision, it doesn't directly mirror what we see in section 4.2b, where we're looking at habitual residence at the time of entering into the contract. But in my submission, the effect would actually cover somebody who has been recruited from abroad and is simply here working as a member of the mission. So in my submission, if one looks at the distinctions that are drawn based on nationality and residence, they do powerfully demonstrate an international consensus that distinctions between the local labour force and others are relevant and justified in this context. I'd also, in this convention, flag up Article 7. This is at page 794, and we see in the first sentence, subject to the provisions of Articles 5, 8, 9 and 11, the sending state may freely appoint the members of the staff of the mission. And we also see in Article 9 that the receiving state may at any time, and without having to explain its decision, notify the sending state that any member of the staff of the mission who's not a member of the diplomatic staff is not acceptable. So if it's diplomatic staff, then persona non grata is the terminology. For anyone else, the receiving state may notify that they're not acceptable without having to give any explanation, and the effect of that is that the person has to be either recalled or functions for the mission terminated. And we do say that it is oddly dissonant if the receiving state is free, in effect, to terminate a person's functions with the mission without explanation, yet the sending state is not free to do so without rendering itself subject to the jurisdiction of the receiving state. And in my submission, if one reads Article 7 and Article 9 together, it is apparent that the freedom to appoint members of the staff of the mission includes a right to terminate an appointment freely too. Just to note briefly then, Article 22, the premises of the mission shall be inviolable, so that's including the ambassador's residence is inviolable. Article 24, the archives and documents of the mission shall be inviolable at any time and wherever they may be. And Article 31, I'm conscious the court has been looking at this, but it's certainly our position that this action could not have been brought against the ambassador, and as we see from subparagraph 2, he cannot be required to give evidence, and the same is true of members of his family forming part of his household, unless they are UK nationals. And this case, both of these cases, are the facts are quite dissimilar to the Reyes case that the court has been looking at. There's no allegation of trafficking or anything of the kind in this case. So the clear purpose and effect of the provisions of the State Immunity Act that we looked at was acknowledged by the courts and by the tribunals below. I'll just turn up page 452 in the core volume. Paragraph 67, the Court of Appeal noted the President of the AAT considered the provisions could not be read down. The judge considered at paragraph 40 that the parliamentary intent expressed in the 1978 Act was to confer immunity subject to specific exceptions. In his view, the Act was framed so as to create a careful, detailed and clear pattern which balances considerations known to the legislature. He considered that if a court or tribunal were to alter the width of a provision, limiting an exception to immunity, or of a clear statement that Section 4 does not apply to particular people, there would be a danger of its affecting the overall balance struck by the legislature, whilst lacking Parliament's panoramic vision across the whole of the landscape. We, that is the Court of Appeal, agree. And so that is something that we also would endorse, particularly the statement that the State Immunity Act is a clear, careful and balanced piece of legislation. And in my submission, the fact that the only possible reading of the State Immunity Act has the effect that Libya has state immunity is of some significance. First, Parliament has granted the causes of action on which Ms. Janah relies. Parliament has also made abundantly clear that if such a claim is brought by a person in Ms. Janah's position, the UK courts do not have jurisdiction to adjudicate against the will of the foreign state. I flag that now as a point to bear in mind when considering the rule of law and legal certainty in the context of the engagement issue. Secondly, in respect of the EU law claims, the court is being asked to disapply primary legislation. Now, we don't take issue with the availability of that remedy if the court were to find that the State Immunity Act is in breach of EU law. But the profound consequence of such a finding, in my submission, calls for particularly intense scrutiny of the contention that the grant of immunity would fall outside currently accepted international standards. As we have noted at footnote 75 of our case, core volume, page 232, citing Fox and Webb, copies of the State Immunity Bill in its original and amended form were circulated to all diplomatic missions in London with an explanatory letter. No substantive criticism of the draft was received from any state. And so we do say foreign states deal with the UK and in the UK on the understanding that the UK courts will give effect to their right to state immunity to the extent specified in the State Immunity Act. Thirdly, as the court will see in due course, when we look at the key Strasbourg cases, part of the Grand Chamber's reasoning in finding against Lithuania in Kudak and against France in Sarbet was based on a finding that the grant of immunity by those states had been inconsistent with their domestic laws. Now, I don't wish to overstate the point. It is a secondary part of the court's reasoning in those cases.
The main ground was that they didn't think that it was an act Ure imperi, which they thought, rightly or wrongly, was the relevant test.
I accept that was the primary ground, but just I would simply note that this is a point of distinction, that insofar as they were relying on the point in both cases that they thought that the grant of immunity was inconsistent with Lithuanian and French law, that isn't the case here. The UK law undoubtedly grants state immunity. So the primary question for the court is whether the grant of immunity in these cases would breach the right of access provided by Article 6 of the ECHR and Article 47 of the Charter. And a secondary question is whether the grant of immunity pursuant to Section 1.1 and Section 4.2b of the State Immunity Act unjustifiably discriminates on grounds of nationality, contrary to Article 14 and also Articles 20 and 21 of the Charter. Within those overarching questions, the key issues are, as I've identified, the questions whether or not this is within the margin of appreciation to grant state immunity on the basis it's customary international law, whether the right of access is engaged, if it is engaged, whether it's breached, and fourthly, whether or not it's unjustifiably discriminatory. So turning then to the first question, which is looking at the grant of state immunity in respect of these claims and whether it is within the legislature's margin of appreciation. And if I might begin by taking the court to the jurisdictional immunities judgment of the International Court of Justice. That's in Core Authorities Volume 3. And it's MS 1564. It's Core Authorities 3, tab 21, 1564. And the court will recall that the Italian courts had declined to grant Germany state immunity in respect of claims brought by Italian nationals against Germany in respect of atrocities committed in Italy and elsewhere during the Second World War. And Germany contended that its right to state immunity had been violated. And turning to paragraph 54, we see that any entitlement to immunity depended on customary international law rather than treaty. The position described in paragraph 54 is the same as here. The UK is a party to the Basel Convention, but Libya and Sudan obviously are not. The 2004 Convention is not yet in force and has not been ratified, acceded to, or accepted by the UK, Libya, or Sudan. If I may, from now on, I'll use the term ratified to cover all of those options. Paragraph 55 reiterates and emphasises that the material of customary international law is to be looked for primarily in state practice and opinio juris. And importantly, over the page, on page 1591, still in paragraph 55, the International Court of Justice identifies state practice of particular significance, the sources that one needs to look at to identify state practice in this context. And what they identify are judgments of national courts faced with the question whether a foreign state is immune, the legislation of those states which have enacted statutes dealing with immunity, the claims to immunity advanced by states before foreign courts, and the statements made by states in the course of the extensive study of the subject by the ILC, and then in the context of the adoption of the 2004 Convention. In respect of opinio juris, they also refer again to assertion by states claiming immunity, that international law accords them a right to such immunity, acknowledgement by states granting immunity, and conversely, assertion by states of jurisdiction. Then paragraph 56, what we see is the general rule of state immunity. So although there has been much debate regarding the origins of state immunity and the identification of the principles, the rule of state immunity had been adopted as a general rule of customary international law solidly rooted in the current practice of states. That conclusion was based upon an extensive survey, and we see that it's one that the International Court of Justice agrees with. Paragraph 57, the court then notes that the rule of state immunity occupies an important place in international law and international relations. It derives from the principle of sovereign equality of states, which is Article 2.1 of the Charter of the United Nations makes clear, is one of the fundamental principles of the international legal order. And they make the point that exceptions to the immunity of the state represent a departure from the principle of sovereign equality. Then turning on to paragraph 64, we see here, this is in the context of a discussion of Article 12 of the 2004 Convention. A reference is there made to the ILC's commentary on the draft articles, and the point there made that the provision was not intended to be restricted to acta iuria gestionis, and we see nevertheless that the court looks at other state practice in ultimately reaching the view that that the particular provision, the exception, was not applicable in the circumstances of this case. Paragraph 66 reiterates the point that the conventions are only relevant insofar as they shed light on the customary international law. The court will see that the respondent places a great deal of weight on the 2004 Convention, which is described as authoritative, but it is only if and to the extent that it can be said to represent customary international law, or that the process itself demonstrates any evidence of state practice, the process of adoption demonstrates it, that it's actually relevant. If it's not customary international law, then it doesn't carry weight. Then paragraph 69, we see the the International Court of Justice's rejection of the contention that inclusion of Article 12 in the 2004 Convention provided any support for Italy's argument that state immunity has been eroded to allow a tort exception in the context of armed conflicts. And so reference has been made, as we'll see later, in the European Court of Human Rights context to construing the provisions of the 2004 Convention strictly. What we see here is a correct and accurate interpretation of Article 12, but it's certainly not a strict one. There's nothing on the face of the 2004 Convention that excludes the acts of armed forces from its scope, but it's been interpreted that way in any event by the ICJ. And if we could skip forward to paragraph 106, just whilst we have this authority open, it's worth noting at page 1613, the point is there made that insofar as the argument based on the combined effects of the circumstances is to be understood as meaning that the national court should balance the different factors, assessing the respective weight on the one hand of the various circumstances that might justify the exercise of its jurisdiction, and on the other hand of the interest attaching to the protection of immunity, such an approach would disregard the very nature of state immunity. As explained in paragraph 56 above, according to international law, state immunity where it exists is a right of the foreign state. In addition, as explained in paragraph 82 of this judgment, national courts have to determine questions of immunity at the outset of the proceeding before consideration of the merits. Immunity cannot therefore be made dependent upon the outcome of a balancing exercise of the specific circumstances of each case to be conducted by the national court before which immunity is claimed.
Does it also follow from the penultimate sentence in that paragraph that proceedings which are begun against a state in respect of matters for which it's immune are not, as proceedings, nullities? Because otherwise it's hard to see how there would be any scope for the court to decide whether the state immunity applied at all. Do you accept that?
Yes, the immunity is an immunity from the substantive adjudication of the claim.
So the proceedings are valid proceedings, but liable to be dismissed on the ground that there's no jurisdiction.
Yes. The clear statement at paragraph 106 that immunity cannot be dependent on the outcome of a balancing exercise is reinforced by the point made at paragraph 101 in the middle of that paragraph that there's no basis, the court could find no basis in customary international law for saying state immunity is dependent on the existence of effective alternative means of securing redress. Now, Ms. Janah relies on the fact that 5 Grand Chamber decisions have taken the view that the grant of state immunity is a restriction on access to the court, which engages Article 6, with the consequence that the proportionality of the restriction is in issue. I'll come back to this when I address engagement, but at this stage I would simply note that jurisdictional immunities postdates all 5 of those Grand Chambers decision, and paragraph 106 lays down a clear marker that the European Court of Human Rights approach needs to be revisited, as it is saying quite clearly that state immunity cannot be part of a proportionality balancing exercise. Turning back finally in this judgment to paragraph 89, in this paragraph, the ICJ addresses the 2004 Convention, and the respondent places reliance upon this, as well as on the observations in the House of Lords in Jones and Saudi Arabia as to the authoritative nature of the 2004 Convention. But this is a point that was addressed by this court in Benkharbouche, so putting away jurisdictional immunities. If the court could take up Core Authorities Volume 2, tab 10, at MS 1158, and it's paragraph 25 in Lord Mance's judgment, where we see both Jones and the jurisdictional immunities case addressed, and the point made here is that those statements have to be read in context.
Sorry, which paragraph?
It's paragraph 25.
Okay.
So by letter H on 1180, it's noted the Convention is not yet in force, lacking a sufficient number of ratifications, including any from the United Kingdom. And the reference to the statement or the observation of Lord Bingham in respect to the Convention in Jones and Saudi Arabia is quoted. The point is made that this was in the context of a statement made expressly about the limits of state immunity in the context of an issue whether the legal liability of a state official for torture fell outside the scope of such immunity. That was a fundamental question which the Convention, however embryonic, could be expected to cover. He rejects the attempt to use Article 6.2b of the 2004 Convention.
Are you submitting that everything in the 2004 United Nations Convention is declaratory of existing customary international law? I don't think you are you?
No, I'm not. I would accept that that there is much of it that one can see from the Travo that was entirely the subject of consensus. Nobody had any difficulties with it. Article 11 was one of the most problematic of all of the provisions, and my submission is that Article 11 of the 2004 Convention does not represent customary international law. So there may be other provisions, and no doubt that there are other provisions that, if one looks at the specific evidence in relation to them, one would see that they in fact reflect customary international law, but that, in my submission, is not true of Article 11.
And a lot of these provisions are designed to achieve a consensus that didn't previously exist. Not perhaps on the fundamental points, but on the more detailed ones.
Yes, but there is then the question as to whether or not one can say that even if a convention doesn't codify customary international law, has it crystallised it or has it subsequently become customary international law? But one can't simply rely upon the terms of the convention for that purpose. One has to then look at the evidence as to whether it in fact reflects.
Unless the convention is accepted or ratified by substantially the whole international community.
Yes.
Which this one obviously is not.
Yes, that's right. And that the level of participation is particularly relevant in this context, where one's looking at state immunity, which is something that affects every state. We're not in the context of international law that specially affects certain states. Every state is affected by this. And so in order to find that an exception has eroded immunity as a matter of customary international law, one needs a much greater level of evidence to show that that is the position of all those states who are affected, which is everyone. Whilst we're in Benkharbouche, if I could just draw attention to, firstly, paragraph 12 in the judgment of Lord Mance, where he endorses paragraph 57 of the jurisdictional immunities judgment, and just to note that also paragraph 181 of Lord Sumption's judgment endorses the same paragraph. And so in my submission, the court should not approach this case as the Strasbourg court has, at least on occasion, appeared to do, on the basis that state immunity is a rather outdated rule which ought to be limited as strictly as possible. As the ICJ said only 5 years ago in jurisdictional immunities, it's a rule that occupies an important place in international law and international relations. Then paragraph 109, I would just note that Lord Mance briefly addresses, albeit over to the engagement question in respect of Article 6, 109 in respect of state immunity, and 110 in respect of foreign act of state. And as this court will, of course, be aware, paragraph 116, Lord Neuberger's judgment endorses those specific paragraphs in relation to state immunity in both Lord Mance's judgment and Lord Sumption's judgment. And in turn, Baroness Hale and Lord Clark, at paragraph 174, endorsed the reasoning and conclusions in the judgment of Lord Neuberger. So, drawing the threads together, we say that state immunity is an important rule of international law. It derives from the principle of sovereign equality, which is a fundamental principle of the international legal order. Historically, as a matter of customary international law, state immunity was absolute. So the general rule remains one of immunity of foreign states from the adjudicative jurisdiction of the courts of the foreign state. However, the general rule is subject to important exceptions. But any exception to state immunity represents a departure from sovereign equality. And the question is whether a state's right to immunity has been eroded in such a way as to allow the court to adjudicate in the circumstances of the case. So it follows that it is necessary to establish the existence and scope of any exception in accordance with the rules of international law governing the identification of customary international law. And that is, in fact, the approach that the European Court of Human Rights has taken. So whilst there are many points that I will be taking issue with, they have taken that approach of considering whether or not customary international law shows that the general rule of immunity has been eroded. So if I might turn then to the Strasbourg case law, starting in Core Authorities, Volume 2, Tab 14, at MS 1372. Now, just to note first that there were 3 judgments of the Grand Chamber, all addressing state immunity and access to the court, handed down on exactly the same day. So 21st of November 2001, the Grand Chamber handed down Fogarty, Al-Adsani and McElhenney. Al-Adsani is in the previous tab, and McElhenney will come to is in Authorities, Volume 9, 573778. And the same constitution considered all 3 cases, save that in McElhenney, the ad hoc judge, Judge Cairns, took the place of Judge Costa. Much of the analysis across the 3 cases is identical. I'll take it primarily from Fogarty, as that's the only one of those 3 judgments which is specifically concerned with an embassy employment dispute. Paragraphs 10 to 14, we see that the employee was an administrative assistant at the US Embassy in London. She brought a claim for sex discrimination, which the US chose to defend. And whilst the claim was pending, she applied for and obtained a 12-month contract as an administrative assistant within another section of the US Embassy in London. Then before her 12-month contract expired, and after she had won her sex discrimination claim, she applied unsuccessfully for 2 other US Embassy posts. She then issued a claim alleging victimisation and discrimination in respect of the refusal to re-employ her. As far as that claim was concerned, the US claimed state immunity. The applicant was advised that she had no domestic remedy, and so she took her claim to the European Court for Human Rights.
Thank you.
The court refers, paragraph 16, we see State Immunity Act provisions that we have looked at.
Yep.
Then the Vienna Convention at 17, the Bâle Convention at 18, and they refer specifically to Articles 5 and also Article 32. And as I say, Article 5 is in the same terms as Section 42B of the State Immunity Act. They then refer to the 1991 draft articles of the ILC. At this point in time, there wasn't a 2004 convention, so they're referring to the draft. And they note on page 1379 within paragraph 19 that although there is no explicit reference to employment at diplomatic or consular missions in these provisions, the commentary indicates that the latter exception was intended to apply in such a context and that all employees at such missions would be precluded from bringing suit on the basis of state immunity. They then refer to, firstly, the 1982 draft convention of the International Law Association, which included a provision in the same terms as Article 5 of the Basel Convention. So that was at the same terms as Section 42B. Then that was amended, we see reference to the 1994 version, and at the end we see the explanatory commentary that the committee wished to make clear that the employment relationship of any and all diplomatic and consular staff and other members of the mission should be immune from the jurisdiction of the courts of the forum state. So the 1994 version is effectively in the same terms as the Section 16 of the State Immunity Act.
It was subsequently amended, was it not, as a result of objections by some participating countries in the international conference, so as to cut down the scope of the immunity. Is that not right? After 94?
I would need to check that. But we'll do that. Sorry. So then, just to flag, paragraphs 25 and 26 address the engagement point, and the essential reasoning is that the state immunity was to be seen as a procedural bar. It does not qualify a substantive right. Therefore, the court reasoned Article 6 was applicable. Then paragraphs 32 to 36, we see the court's assessment, and just to note that paragraphs 52 to 56 of Al-Adsani are in exactly the same terms, and paragraphs 33 to 37 of McKelleney are in exactly the same terms. So 32 to 36 is common across the three Grand Chamber judgments. Might I ask the court to read paragraphs 32 to 36?
32 to 36. If you want to sit down while we do that, you're welcome to do so. Yes, thank you.
Thank you. The points I would just draw out from that passage, firstly at paragraph 32 we see that access to the court, it's not an express right, but it is implied on the basis it is inherent in Article 6, interpreted by reference to the principles of the rule of law and the avoidance of arbitrary power. And paragraph 36, we see that the limitations generally accepted by the community of nations as part of the doctrine of state immunity are also to be regarded as inherent in Article 6. So I flagged both the underlying reason for implying a right of access and also the fact that Article 6 is inherently limited by state immunity as important points which will go to the engagement issue in due course. Just to anticipate the point briefly, my submission will be that the substantive procedural distinction only goes so far. It is relevant to the extent that the European Court of Human Rights may not create a substantive civil right which does not exist in domestic law, but it does not follow that Article 6 should be interpreted as giving a prima facie right to an adjudication of a substantive claim, deprivation of which must be justified in circumstances where the court has no power to adjudicate. Paragraph 34 identifies the legitimate aim, and that has been found to be established in all the subsequent state immunity cases. Whether or not a breach of has been found, the legitimate aim has been accepted in those terms. So turning then to the way in which the court then addresses this specific case, paragraph 37, the first sentence, the court observes that on the material before it, there appears to be a trend towards limiting state immunity in respect of employment-related disputes. The extent of this apparent trend can be seen from the material that the court referred to, footnote 8. So the court's there, footnote 18. The court's there referencing paragraph 16, State Immunity Act, paragraph 17, the VCDR, 18 is Articles 5 and 32 of the Basel Convention, 19 is the draft Article 11 of the 1991 draft articles, the 1982 and 1994 ILA drafts. So those are paragraphs 16 to 20.
Yeah.
And 29 and 31 are the submissions of the parties.
Yeah.
So,
Thank you.
in the sense that, I mean, of course, if one looks at the State Immunity Act, it does demonstrate a trend towards limiting state immunity. It limits it to the extent that we see in Section 4, read together with Section 16. But what one doesn't see is, and it is limiting it to a quite restricted extent on the basis of the material that was before the court. In November 2001, when the court was giving judgment, the apparent trend found by the Grand Chamber was entirely consonant with the degree to which state immunity in respect of employment contracts is limited by the State Immunity Act. Paragraph 37 then goes on to note that international practice is divided in relation to the application of state immunity in embassy employment cases. And the way they put it is, certainly it cannot be said that the United Kingdom is alone in holding that immunity attaches to suits by employees at diplomatic missions, or that in affording such immunity, the United Kingdom falls outside any currently accepted international standards. And so my Lord Sumption asked what I meant by idiosyncratic. In my submission, if the state had been alone, if the state was affording immunity which falls outside any currently accepted international standards, then it would be acting idiosyncratically. But if it is not doing that, then it is granting immunity to an extent accepted as being within its margin of appreciation. At paragraph 38, the court then makes an additional point. The court further observes that on the facts of this case, that there's no trend eroding state immunity in respect of recruitment to foreign missions. And paragraph 39, we see the conclusion that the UK had not exceeded its margin of appreciation in granting state immunity.
What this woman's job, or the jobs for which she'd applied, am I right in thinking that she was not a member of the diplomatic staff of the US Embassy, but a member of the so-called administrative and technical staff?
Yes.
She was a lawyer, basically, in government service, wasn't she?
What she described as an administrative assistant, I don't know whether that
Right.
amounts to a lawyer. It may do. But yes, I would accept she's within the administrative and technical category.
I mean, she wasn't just a secretary.
I think I might object to the words just a second.
Yes, I take it back. She was more senior than that, I think, looking at the posts she was applying. Well, hang on, maybe that's not right, actually.
Yes.
She was applying for secretarial positions in...
She applied for
Two other
temporary
sections.
secretary.
Yeah.
Yeah. So,
Yeah.
well, I'm not sure there's any appearance of
No, she
seniority.
looks as if she was secretarial staff.
Yes. If I can turn next to the second of the Grand Chamber decisions made on the same day, Al-Adsani, that's in tab 13 of Core Authorities 2, so the previous tab,
Thank you.
1343, and I'm sure my lady will be familiar with this case. It's a Jones type case concerning claims of torture. So this one isn't a specific embassy employment dispute case. Paragraphs 46 to 49 are to the same effect as we've seen in Fogarty on the question of engagement. And as I've said, 52 to 56 are identical to 32 to 36 of Fogarty. Paragraph 57, we see the court notes that the 1978 Act applied by the English court so as to afford immunity to Kuwait complies with the relevant provisions of the 1972 Basel Convention. And then at paragraph 61, the way in which the court addresses this question towards sort of halfway down paragraph 61, it says the court is unable to discern in the international instruments, judicial authorities or other materials before it any firm basis for concluding that as a matter of international law, a state no longer enjoys immunity from civil suits in the courts of another state where acts of torture are alleged. And that term's firm basis is reiterated at paragraph 63. And this approach, in my submission, is consistent with the way in which state immunity has developed. Customary international law recognised absolute immunity. That's no longer the position, but whenever an exception is claimed, a firm basis is needed for concluding that customary international law has reached the point where the pre-existing immunity has been eroded and a customary international law exception created. And at paragraph 66 in Al-Adsani, we see the way in which the test at paragraph 56 has been applied. So the test, which goes across all of these cases, that measures taken by a high contracting party, which reflect generally recognised rules of public international law on state immunity, cannot in principle be regarded as imposing a disproportionate restriction. The way in which that's then applied in paragraph 66, the court doesn't find it established that there is yet acceptance that states are not entitled to immunity. And the State Immunity Act, which grants immunity in this context, is not inconsistent with those limitations generally accepted by the community of nations as part of the doctrine of state immunity. So then the third of the trio is in Core Authorities Volume 9.
Core Authorities, tab 9.
Sorry, not Core Authorities. Authorities 9. It's Authorities 9, tab 57.
Bundle 9.
MS 3778.
3778.
3778, yes.
Thank you.
If the court is solely working off electronic versions in relation to, and I'll just give the MS numbers in that case for this. This case concerned an incident at the border between Ireland and Northern Ireland, and the applicant was involved in an incident at a checkpoint in which he ended up driving 2 miles into Ireland with a British soldier clinging to his vehicle, and then when it stopped, the soldier fired at the applicant's car and at the applicant. The applicant sought to bring a personal injury claim against the UK before the Irish courts. And the Supreme Court of Ireland dismissed the claim on the grounds that the UK had state immunity. The judgment begins at paragraph 20.
Page.
3785. And the analysis in relation to engagement is the same as we've seen already. I'd note at paragraph 27, 3787.
Yes.
The submissions made on behalf of the Government of Ireland in respect of the Basel Convention. Ireland, which is itself not a party to the Basel Convention, made the point that the limited number of ratifications or accessions could be taken as an indication that many states were not willing to countenance all the exceptions to the doctrine of state immunity set out therein. Then paragraphs 33 to 37 are the analysis that we have seen previously. So then looking at paragraph 38, in similar terms to what we've seen in Fogarty, but in this different context, the court notes a trend towards limiting immunity, in this case in respect of personal injury. But they say this practice is by no means universal. And they also note that there may be a question as to whether it just extends to insurable personal injury. And then again, in similar terms to what we saw in Fogarty, they say certainly it cannot be said that Ireland is alone in holding that immunity attaches to suits in respect of such torts committed by actor Urian Perry, or that in affording this immunity, Ireland falls outside any currently accepted international standards. They agree with the Supreme Court of Ireland that it is not possible, given the present state of the development of international law, to conclude that Irish law conflicts with its general principles. Before turning to the two more recent Grand Chamber decisions in embassy employment cases, it should be noted that the Strasbourg Court's approach in this trio of cases is far removed from that taken by the Court of Appeal. Now, the Court of Appeal acknowledged in paragraph 21, which is core volume, page 430, and sees
Yes,
between B and D on page 430,
thank you.
the acknowledgement that in some areas it is unclear to what extent immunities have been eroded, and they acknowledge that nowhere is this difficulty more apparent than in the field of embassy employment disputes with which we are concerned in the present cases. They note that state practice and the decisions of national courts reveal a variety of different approaches and a diversity of views. And in my submission, it's plain that on the approach taken in Fogarty, Al-Hadsani and McElhenney, in such circumstances, the court would have held that the UK did not exceed its margin of appreciation by granting immunity. If there is that extent of different approaches and diversity, then the position applying the approach in those three cases would clearly be that the margin of appreciation is not exceeded.
Do they grapple with that point expressly?
Well, they state that they are applying a margin of appreciation, and what they say is that the State Immunity Act falls outside the range of tenable views as to what is required, and there isn't. In my submission, there is an inconsistency between, on the one hand, accepting this diversity of approach, and on the other hand, suggesting that the UK's approach is not tenable.
Well, they do that because of the later cases, don't they?
They do, and I will come on to those. Before I do, I would just go at this point to the 2004 convention itself, which is in Core Authority, Volume 1, it's tab 4837. And this, of course, it didn't exist at the time that the authorities we've just been looking at were given, but it's then in existence and is then considered in the cases that we are coming to.
Thank you.
So we see within the preamble by the believing point that the aim is to contribute to the codification and development of international law and the harmonisation of practice in this area. So it's partly codification, but it is also partly development. Article 3 refers to the immunities enjoyed by a state under international law in relation to the exercise of the functions of its diplomatic missions and of persons connected with its diplomatic missions. So this convention is without prejudice to any such privileges and immunities enjoyed by the state under international law. And so...
That's about diplomatic immunity, isn't it? Which is an immunity of the state, but attaching to the acts and status of individual people connected with a mission.
Well, insofar as international law grants states any immunity in relation to the exercise of the functions of its diplomatic missions or persons connected with diplomatic missions, on the face of it, this convention is without prejudice to that. And so certainly that would include diplomatic privileges and immunities, but on the face of it, it's without prejudice to any that there might be under international law, which would include customary international law. We see at paragraph 4 the non-retroactivity of the present convention. So this convention is not in force, but it also doesn't apply to any proceedings before it comes into force. Article 5 states the general principle, and so it's similar in a sense to the State Immunity Act, where one has the general immunity stated, and then that is made subject to the express exceptions that follow. Article 11, which is the key provision, is at 841, and the structure of it is firstly to...
So looking at Article 6.1, Ms. Stein, a state shall give effect to state immunity by refraining from exercising jurisdiction. Is that going to help us at all on the engagement point?
Well, in my submission, I mean, if one's looking at Articles 5 and 6 together, one sees that that the foreign state is immune from the jurisdiction. So the position under Article 5 is clearly that the courts of the foreign state do not have adjudicative power. And so the fact that they have to refrain from exercising jurisdiction it's perhaps using it in a slightly different sense. They're not, they don't have an adjudicative power to exercise, and so it would be a breach if they were to try and assert one.
They have jurisdiction to decide whether they have jurisdiction.
Yes, that's certainly true. Yes.
So what's the status of this document?
Well, this is, it is a convention which is not yet in force. It's a convention which the UK has not ratified. It has not been ratified by Libya or by Sudan either. And so...
It's simply evidence of customary international law, so far as its object is to declare it as opposed to bringing in new rules.
Yes, well, in my submission, that certainly in respect of Article 11, Article 11 is plainly not declaratory of existing customary international law. So it is not evidence of customary international law to that extent. And so, and when one looks, for example, the way in which this convention was treated in the jurisdictional immunities case, actually what was relevant more than anything was the process building up to the convention, the statements made by states in the context of agreeing and drawing up this convention, as opposed to this convention itself, which it's a treaty which is not binding and not in force. So looking then at Article 11, we see the way that it is structured is firstly to state a relatively broad employment contract exception in paragraph 1, but that's then narrowed by subparagraph 2. And if one looks at the various exceptions to the exception within 2, they are quite different to what we will see when we look at the 1991 draft, the Article 11 draft. The two are quite distinct. In particular, there is an amendment to A, where it had previously referred to the terminology of being closely related, and that was amended. B is not in the draft article, so that is something that appears later. D is also not in the draft articles, and E is amended to some extent. And this draft also excludes a provision that had been in the draft articles as 11.2c. That's then gone from this version. Our submission in relation to this convention is that it does not represent customary international law. Article 11 doesn't represent customary international law. But if we did need to look at the scope of Article 11, it would then be necessary to construe Article 2b for any other person enjoying diplomatic immunity, because the exception doesn't apply in the case of any other person enjoying diplomatic immunity. And we've already seen in the Article 37 of the Vienna Convention on Diplomatic Relations that that certain service staff and certain administrative and technical staff do enjoy diplomatic immunity.
So would it catch Ms. Janah
Well,
in your case?
my primary case, as I say, is that this doesn't represent
I understand
customary
that.
international law. But
But
if,
assuming it did,
assuming against me that this were customary international law, then in my submission it does. Now,
But surely the diplomatic immunity is only enjoyed as under the Vienna Convention in the case of effectively, well, it doesn't apply to people who are either nationals of or permanently resident in the receiving state.
that's right.
So that they wouldn't enjoy the diplomatic immunity that would trigger subparagraph 4.
That's right. So it would be true to say that Article 2 B4 would not be as extensive as Section 16 of the State Immunity Act. It would be more limited than that, but it would cover our position here in respect of those who do in fact have immunity under Article 37 of the Vienna Convention.
I mean, more broadly, Article 11 appears to contemplate that the immunity in relation to employment is not limited to exercises of sovereign authority. And that, I think, is a proposition that you do rely on, isn't it?
I'm sorry.
As I understand it, you say that the distinction between acts iure imperii and iure gestionis is not, at least in the field of employment, the critical test in customary international law. And that's a proposition that this article appears to accept.
Absolutely. In this context, at least, that distinction is relevant, but the fact that something is not iure imperii is not a complete answer, because there also needs to be the nexus and connecting factors with the forum state, and this is this provision makes clear that immunity continues to apply in circumstances where it doesn't fall within Article 2A. So one has Article 2A, which is effectively the performance of functions in the exercise of governmental authority, but then there is an additional coverage in respect of others. Now, the Court of Appeal addressed this at paragraph 38, core volume 439.
Right?
If I could just ask the court to read paragraph 38. So the Court of Appeal has acknowledged what they refer to as the literal reading, what in my submission is the ordinary meaning of the phrase any other person, and I would stress any, enjoying diplomatic immunity. On the face of it, that would encompass a person such as Ms. Janah, who has diplomatic immunity pursuant to Article 37.3 of the Vienna Convention.
What do you submit is the rationale of that? I mean, on the face of it, it seems slightly odd that a person's right to sue a state in the United Kingdom should depend on whether, in relation to other matters entirely, namely the performance of their functions, other people can sue them.
Well, the grant of immunity and also the privileges of not being taxpayers and so on in the Vienna Convention, that identifies a certain category of employee. It identifies those who are not members of the local labour force. And so what one is then doing if one's applying that across to say that that state immunity is not eroded in that context, is one's looking at the connecting factors of, on the one hand, those who are members of the UK labour force, compared to the relative lack of connecting factors of those who have been recruited from abroad to work for a foreign embassy that happens to be in this country. And so that would be, in my submission, the rationale. Now, the Court of Appeal notes that in 2002, the ad hoc committee was confronted with a choice between alternative drafts, which in what became Article 11.2b.1, on the one hand, there was a provision that would have encompassed all members of a diplomatic mission. On the other hand, there was a provision that was limited to those qualifying as diplomatic agents. And the committee opted for the narrower of those two. Now, the Court of Appeal suggests that the fact that they opted for the narrower version shows that interpreting this article as including somebody such as Ms. Janah would defeat the intention in going for the narrower version. But it needs to be understood, of course, that the Vienna Convention in Article 37 doesn't encompass all members of a mission. So the interpretation that we put upon it, it doesn't go as far as the broad version, but it is narrower. So it is narrower than all members of a mission. It's only encompassing service staff and administrative and technical staff who actually have the immunities under Article 37. And so in my submission, one can't take it from the fact that in respect of that provision in the draft, the fact that people on the committee rejected an immunity in respect of all members of a mission doesn't show that they didn't want it to cover those who have diplomatic immunity. And in my submission, if one's looking at the ordinary meaning and the emphasis on any person enjoying diplomatic immunity, it is difficult to see how it can properly be interpreted as being narrower. The Court of Appeal's interpretation is that it's limited to a residual category of miscellaneous persons of diplomatic status. And that's not consistent with the any other person. And it's also unclear who might then be covered by it. And in particular, who is it suggested might be covered who wouldn't already be covered, for example, by 11.2a. Then, turning back to the 2004 convention, just to highlight a couple more provisions within it. Article Article 29 indicates that this is a treaty by which parties become bound if they ratify, accept or approve it. And the entry into force is specified in Article 30. And then in the annex to the convention, which is MS 851, there is an understanding specified with respect to Article 11, and in particular the second paragraph, and we see towards the end of that paragraph that the point is made that under Article 38 of the Vienna Convention on Diplomatic Relations, the receiving state has a duty to exercise its jurisdiction in such a manner as not to interfere unduly with the performance of the functions of the mission or the consular post. If it were necessary to interpret the 2004 Convention, one would have to have regard to that understanding.
What does that mean?
Well, it's in my submission, it supports our submission as to the scope of coverage of Article 11, because investigation of embassy employment disputes is something that would interfere with the performance of the functions. Whoever one is looking at, whichever level of employee, the fact is that what one is looking at an embassy and looking at the internal management of that embassy is inevitably going to be an issue in circumstances where employment disputes are brought before the court. And so...
Does that apply to, I can see that might apply to diplomatic staff and possibly administrative and technical staff, but would it apply to domestic staff? It's hard to see that one's interfering with the functions of the mission by adjudicating on the lawfulness of the termination of domestic staff.
Well, in my submission, it would. One is inevitably looking at the way in which diplomatic agents, for example, are managing employees within their embassy, looking at the actions of the diplomatic agents or other members of the mission. And so one is going to be investigating matters, certainly in the context of something like a claim for dismissal. And the very fact that we've seen the freedom to appoint, and the flip side of a freedom to appoint must be a freedom to cease to employ an individual as well. And it is hard to see how one can regard...
Even if it's in breach of the contract?
Well, it is a... Yes, in my submission, the freedom...
It doesn't seem to me that freedom to appoint is anything like the same thing as freedom to dismiss. It strikes me as entirely different things.
Well, the purpose is to ensure that it is a matter for the mission who they employ, subject to the provisions in the Vienna Convention that, for example, enable the receiving state to say that a person is unacceptable or persona non grata. Subject to that, it is a freedom to for the foreign state to determine who should be members of staff of their mission.
But I mean, that can't apply generally because, for instance, if you were a member of the domestic or technical and administrative staff who was a national of the receiving state, then you wouldn't have the benefit of Article 11. And so, in that situation, there would be jurisdiction to investigate the hiring and firing policies.
I accept that would be the position under Article 11, yes.
It would also follow from Article 11E. We have permanent residence in the state of the forum.
What one has is a sort of balancing there that the UK labour force have much stronger connecting factors with the UK, and so as a result, certainly in the context of agreeing the 2004 convention, one has a position where those employees will not be met by state immunity. If I may then turn to the Strasbourg, subsequent Strasbourg cases, the ones that are subsequent to the 2004 convention. And the first of the cases to look at is in Core Authorities, Volume 2, Tab 15, MS 1392. And this is Kudak and Lithuania. Now, the applicant was a Lithuanian national. We see that from paragraph 43. She was recruited to work for the Polish embassy in Lithuania as a secretary and switchboard operator, and she was dismissed and brought a claim requesting compensation for unlawful dismissal. At paragraph 16, we see the Polish Minister for Foreign Affairs issued a note verbal claiming immunity from the jurisdiction of the Lithuanian courts. Now, I mentioned in the context of looking at the sources of state practice and opinio juris that the International Court of Justice identified, that claims for immunity and the grant of immunity are both forms of state practice. So here, although we see that the European Court of Human Rights has held that granting immunity was a breach of Article 6, as a matter of identifying customary international law, identifying state practice, we have state practice of from Poland in terms of the claim for immunity, and we have state practice in terms of the Lithuanian courts granting immunity.
So why does a claim help us on practice?
Because it involves the state asserting immunity. It's the practice of the state asserting that it has immunity, and so it helps both in terms of state practice and opinio juris, and that's what the International Court of Justice said specifically in the context of state immunity. It was identifying what the sources are. It was identifying claims by states for immunity, and also any decisions of courts any decisions of domestic courts granting immunity.
Is this part of your point that if Poland claims immunity, it must follow that Poland's law grants immunity? Because I understood vaguely, I have to say, that that was one of the things that was said.
Well, what it says is that Poland is asserting, on the international plane, it is asserting that it has a right to state immunity. So that is a statement on behalf of the state as to what it says customary international law in respect of state immunity is.
Well, surely it's actually based on the relevant provision of the Polish Code of Civil Procedure, which is quoted at paragraph 20. And actually, the Polish minister's assertion doesn't really add anything to that. I mean, 4791, maybe one should look at the rest of the provision of the code, but 4791 appears to be an assertion of absolute immunity.
Well, that's Lithuanian law, but also we see that although that is how those are the terms of the provision, but we see in paragraph 21 that Lithuanian legal practice follows the doctrine of restrictive state immunity. So there's reference there to the Lithuanian Supreme Court. So one's got two different pieces of evidence of state practice. One has the state of Poland, represented by its foreign ministry, asserting that it has a right to state immunity, and one hand has the courts, and so Lithuania via its courts also acknowledging state immunity in the context of this case. And it's a much more general point that I make. I'm not going to make it in respect of all of the domestic cases and so on that one has before you. But what I do say is, when one is looking at those, it's not enough to say, well, the court refused to grant immunity. When one is looking at evidence of state practice, if there is a claim by a state for state immunity, that is also evidence of state practice and of opinio juris. And whilst it might be tempting for a court to give rather more weight to a judicial decision than to an assertion of immunity on the part of the state, the fact is that in this context, one is looking at what the state is saying, whether through its judicial organs or through the executive or legislature, and each of those is taken into account. Then paragraphs 39 to 47, the court addresses the applicability of Article 6, but is not here doing so by reference to the nature of state immunity as such. So it doesn't really tell us anything as far as the engagement issue is concerned. It's looking at a slightly different issue. Paragraphs 54 to 59, the court addressed the general principles in very similar terms to Fogarty, and it cites Fogarty at paragraphs 56 to 57. So there's no change in the test that's applied. At paragraph 60 to 62, the court addresses legitimate aim, and although noting a potential distinction, the court follows Fogarty in finding that the Lithuanian courts pursued the legitimate aim of complying with international law to promote comity and good relations between states. Now, at paragraph 74, we see the Grand Chamber's conclusion that the grant of immunity was not proportionate and that it overstepped the margin of appreciation. It's important to scrutinise the court's reasons for these findings, which begin at paragraph 63.
Right.
So first, the court found already in the Fogarty judgment that there was a trend in international and comparative law towards limiting state immunity in respect of employment-related disputes, with the exception, however, of those concerning the recruitment of staff in embassies. Now, in my submission, that summary of what the court found is not entirely accurate. It is somewhat misleading. Firstly, the court has converted the rather more equivocal observation in Fogarty that there appears to be such a trend into a finding that there was a trend. Secondly, the trend referred to in Fogarty has to be understood by reference to the material relied on in Fogarty in the footnote 18 at MS 1384. The trend referred to in Fogarty was evidenced by, amongst other materials, sections 4 and 16 of the State Immunity Act, articles 5 and 32 of the Basel Convention, and the ILA draft, which reflected sections 4.2b and section 16 of the State Immunity Act. So it is true that these limit state immunity in respect of employment contracts, but they demonstrate no trend in respect of embassy employees or in respect of employees other than the local labour force. Thirdly, paragraph 63 of QDAC omits the finding in Fogarty that in relation to embassy employment, international practice was divided, that the UK was not alone in the stance it took, and that the grant of immunity did not fall outside currently accepted standards. Then what we see, turning over to paragraph 67, we see the court there affirming that Article 11 of the International Law Commission's 1991 draft articles, on which the 2004 Convention was based, applies to the respondent state under customary international law. So that's the finding that they make. And the court's reasoning for that is at paragraph 66. Now, the first point I would note is that if that were right, if Article 11 of the draft articles is customary international law, then Ms. Janah loses because Article 11 of the draft articles included a provision which is to the same effect as Section 4.2b of the State Immunity Act. However, I'm not pinning my mask to that one because the court's reasoning and conclusions at paragraph 66 to 67 are seriously defective in my submission. First, at paragraph 66, the court relies on the commentary to the 1991 draft articles.
What's the reference to the 1991 draft articles?
Sorry, the reference.
Where in the bundle is the? Where in the bundle?
The
I'm not
draft-
asking you to. I just want the reference. I'm not asking you to turn them up.
Yes. Sorry, one moment.
Well, in a moment, so maybe your junior will get it. Thank you.
So what they refer to is the commentary, and that, and they refer to the fact that it says the rules formulated in Article 11 appear to be consistent with the emerging trend in the legislative and treaty practice of a growing number of states. Now, the footnote
Yep,
23 on page 148
yep.
cites page 44, paragraph 14 of the commentary.
Yes.
So if we could go to that to see what it's saying, that's in, it's MS 6675.
Thank you.
And so this is the commentary to the 1991 draft. So it does include within it the version of the articles contained in the draft. And if the court could go to 6675.
Yeah,
This is within the commentary on Article 11, and the passage that the court in Kudak has cited is paragraph 14. The rules formulated in Article 11 appear to be consistent with the emerging trend in the recent legislative and treaty practice for a growing number of states. So what's then cited at footnote 147 is the UK State Immunity Act, and then the State Immunity Acts for Pakistan, Singapore, South Africa, Australia, and also the Basel Convention, all of which are said to be worded in similar terms. So the emerging trend that they're identifying is one which is entirely consistent with Section 4.2b of the State Immunity Act, one that they're actually citing as evidence of that emerging trend. The second point made relates to Section 4.2a of the State Immunity Act and equivalents in other foreign legislation which grant immunity to the employer state if the employee is a national of that state at the time when the proceeding is instituted. So one can see on its face, the commentary does not assert that Article 11 of the draft articles is customary international law. But in any event, one has to look to the evidence of state practice relied on in support of that statement in the commentary. And as one can see, the identified emerging trend in the passage relied on fully supports the grant of state immunity in accordance with Sections 1 and 4.2b of the State Immunity Act in respect of foreign state employees who are not locally recruited.
I mean, what this seems to suggest is that in Kudak they are moving away from the notion expressed in Fogarty, that you start with the absolute exemption and you work out whether there is a sufficient consensus about the exception. They appear to accept that there isn't a sufficient consensus, but nevertheless find a violation. I mean, that may or may not be the right thing for them to have done, but that seems to be what the difference is.
In my submission, they're not changing the test, because what they are, well, they may be altering the test for the identification of customary international law, perhaps, but they are finding that as a matter of customary international law, there is an exception which has the scope identified in Article 11 of the 1991 draft article. So that's the finding they are making, is that that exception is customary international law. So in my submission, the commentary doesn't support an assertion that Article 11 represents customary international law. At MS 6673, what we see in paragraphs 3 and 4 is a description of the competing interests of the forum and employer state. And then what's said is that Article 11 endeavours to maintain a delicate balance between those. And at paragraph 6, it said that Article 11.1 presents an effort to state the rule of non-immunity. There's no suggestion there that what they are stating is itself customary international law. And one can compare that with what they say at 10 in respect of one subparagraph, where they identify that paragraph 2b is designed to confirm the existing practice of states in support of the rule of immunity and the exercise of the discretionary power of appointment or non-appointment by the state of an individual. So where they do see it as reflective of customary international law, they say it. It's also worth bearing in mind when looking at the commentary and taking into account the way in which Kudak placed weight on it, the observations in O'Keefe and Towns in respect of it. We have that in Core Authority Volume 3, tab 25.
Just before you look at that, just before we get leaving Kudak, in Kudak...
Sorry, I'm not going to leave...
Oh, you're coming back. All right, but I'm just wondering about what the individual actually did in Kudak. Anyway, come back.
Yes, I will come back to...
He was a telephonist.
Core Authority 3.
So, Core Authority 3, tab 25.
Thank you.
MS 1729.
Thank you.
The final paragraph on that page.
That said.
Yes, that said, one surprising obstacle to a proper understanding of the Convention is the ILC's commentary to its draft articles. And they make the point, not only are the draft articles different in certain crucial respects from the eventual Convention, with the consequence that even the most reliable guide to the former would bear only imperfect relation to the latter, and that's, of course, clearly applicable in our context. Even more to the point, the ILC commentary is not always a reliable guide to the former. Much of its content, as finally adopted, was simply carried over from the respective commentaries provisionally adopted on first reading, despite the fact that many draft articles underwent significant amendment in the interim. As a consequence, the commentary is unlikely to attain a status comparable to that of, for example, the Commission's commentaries to the 2001 articles. So they say it remains useful, but its status is not quite that one might expect of a commentary to a treaty.
I like the last sentence just above paragraph 2.4.
Then, turning back, if I may, to final points on Kudak, paragraph 66, which is 1408, if the court still has it, it's Core Authority 2 at tab 15. So we've looked at the first sentence, and the second sentence goes on, this must also hold true for the 2004 Convention, Furthermore, it is a well-established principle of international law that even if a state has not ratified a treaty, it may be bound by one of its provisions, insofar as that provision reflects customary international law, either codifying it or forming a new customary rule. Moreover, there were no particular objections by states to the wording of Article 11 of the draft articles, at least not by the respondent state. As to the 2004 Convention, Lithuania has admittedly not ratified it, but did not vote against its adoption either. So that's what they say before they reach that conclusion that the 1991 articles are customary international law. Points to note in response to that. Firstly, Article 11 of the 2004 Convention differs substantially from Article 11 of the 1991 draft articles. So if the latter represents customary international law, then the former cannot do so. Secondly, the 2004 Convention was adopted by a committee of the General Assembly without a vote, so it's not clear quite what the court is referring to in terms of the lack of a vote against by Lithuania. But in any event, we would question how a state can become bound by convention provisions because it did not object to a treaty being opened up for ratification by any states who wish to be bound by it. The 2004 Convention makes clear in Article 29 how states become bound by it, and that certainly doesn't include omitting to vote against its adoption by the General Assembly.
Is it referring here to adoption by the General Assembly or to adoption by the Commission?
My understanding is that it's referring to adoption by the General Assembly.
I mean, was there an international conference before the adoption of the final text? If so, it could equally be a reference to that.
We have the
I mean,
various provisions in...
you can come back with an answer
Yes.
to that later when it's more convenient.
Certainly. We make the point that, of course, the 2004 Convention is not in force. And in any event, and treaties cannot create customary international law or conclusively attest to it in and of themselves.
Well, they can if they're virtually universally accepted, but clearly draft treaties can't.
Yes. I was going to look next at the ILC's conclusions on the identification of customary international law. So,
How are we doing in terms of timing? You're aware that we've had a slightly extended hearing this afternoon, and we're similarly doing that tomorrow, and indeed on Thursday morning, to allow for the fact we're accommodating this hearing in 2 days, effectively. How are we doing in terms of your timing?
I think we're doing fine. We will have to be doing fine. So that's, yes, we will keep within our time.
Well, I think we'll rise now and resume again at 10 o'clock. Thank you very much. Court adjourned.